This is Michael Popok, Legal AF. I can't emphasize this enough. This is the most momentous term in the United States Supreme Court history concerning the presidency and our constitutional republic and the role of the criminal justice system and aspects of the Constitution concerning an out-of-control presidency. This is it. This is where the rubber meets the road. It starts this Thursday with oral argument about whether Donald Trump was an insurrectionist and committed rebellion against the Constitution and therefore should be banned from the ballot under the 14th Amendment, Section 3. But that's not all. In April, the United States Supreme Court is going to decide whether 2 out of the 4 counts brought by the Special Counsel's Office, Jack Smith, in the D.C. election interference case presided over by Judge Chutkan, are going to survive or if they have to be dismissed. The 2 related to obstruction with an official proceeding, which were brought against not only Donald Trump, again, 2 out of his 4 counts in the D.C. election interference indictment are based on that, but also against other Jan 6 defendants. That's in April. That would have been after the start of the trial of Donald Trump in the D.C. election interference case, but that case is not going to start now until after oral argument or maybe even a rendered decision, and we'll talk about that next. But there's a third major case that's coming, not just this Thursday oral argument, not just the oral argument in April, but this future oral argument that should take place sometime in February or in March, more likely in March, after the D.C. Court of Appeals finally gets around to ruling. Is it going to be tomorrow? Is it going to be Tuesday? Who knows? Concerning Donald Trump's assertion of absolute presidential immunity against criminal conduct to seek the dismissal of his indictment in the D.C. election interference case. That case, we have to first get the decision from the D.C. Court of Appeals, and then it has to go up to the United States Supreme Court, who's already indicated that they'll take the case after the initial decision by the D.C. Court of Appeals after full briefing. So you've got not 1, not 2, but 3 separate cases. Never in the history of the United States Supreme Court has there ever been such a coalescing of momentous decisions that go to the heart of our constitutional republic and how the presidency fits into the checks and balance and 3 co-equal branches of government. Never. Now look, there's one person on the Supreme Court now who was on the Supreme Court in Bush versus Gore in 2000 when in that unsigned decision, the Supreme Court picked the president, and that was Clarence Thomas. Everybody else that's on this current court were not on the court as judges. However, at least 3 of the members of the current Supreme Court, including the Chief Justice, John Roberts, were involved in Bush versus Gore about whether there were improper ballots being used and improper balloting being used in the state of Florida. I won't go into all the gory details, no pun intended, but there was a ballot that was used in one part of Florida, it's known as the butterfly ballot, that probably led to improper voting for Pat Buchanan, a third-party candidate, and those votes likely should have gone to Al Gore because of a mistake in the way that the ballot was printed and the way that it was used. The Supreme Court, U.S. Supreme Court, had to decide the issue after the Florida Supreme Court had allowed continued counting, manual hand counting of the ballots. The Supreme Court, 5-4, put an end to that and declared Bush the winner. And that's how we got George W. Bush II, or whatever it was, as our president. But John Roberts worked as a lawyer on the Bush side related to that matter, as did Amy Coney Barrett, as did Kavanaugh. And they all got eventually onto the United States Supreme Court. So they have a background in this world at the intersection of law and politics, which, of course, usually the Supreme Court finds to be quite unsavory, but they're not going to have a choice here. They're not going to be able to do what they normally do, which is sort of kick the can down the road and say, well, this is a political question, and under the political question doctrine, the United States Supreme Court could stay out. They are the last stop on the train as it relates to whether Donald Trump is an insurrectionist and committed rebellion against the Constitution to disqualify him from the ballot, and to make the decision about who makes the decision under that 14th Amendment and the language there as to whether somebody is barred and banned and disqualified. It's got to be the United States Supreme Court. They can't punt it back to Congress, although that's a easy exit ramp for them that's been proposed by Donald Trump everybody else in the thinking world in our democracy that's filed an amicus brief, all of the legitimate legal scholars, Civil War scholars, former judges, Federalist Society, lions of the Federalist Society like Judge Michael Luttig have all basically told the United States Supreme Court that the Civil War era drafters of the 14th Amendment, Section 3, would be shocked that we weren't automatically applying this to Donald Trump to have him banned from the ballot, that he was exactly what they were anticipating to prevent a future insurrection in this country under the Civil War amendments, including the 14th Amendment. And so you have that. That's going to be oral argument this Thursday. We'll get the audio version of it, the audio version of the oral argument. We'll have that, and we'll be able to talk about it on Legal AF and on the MeidasTouch network. And very interestingly, the Solicitor General, talk about, sort of Biden staying out of it. I know Donald Trump likes to talk about it's the Biden Department of Justice. They've been weaponized to go after him, two systems of justice, whatever malarkey he talks about. But in reality, the Solicitor General, which is often referred to as the 10th Justice on the United States Supreme Court, that's how respected that office is, and argues, just dozens and dozens of times during a particular term, and has a lot of gravitas and a lot of influence over the results of the United States Supreme Court, has not taken a position or filed a brief related to the ballot 14th Amendment Section 3 disqualification issue. Now, some people might be scratching their head in the audience and going, well, how can they not? I mean, because they're staying out of it and they're letting the private litigants, the Citizens for Responsible ethics, whatever it is, crew that's brought the Colorado case, which is the basis for the appeal. It's the kind of the entry into the case by the United States Supreme Court, which the Colorado Supreme Court, by a 4-3 vote, found that Donald Trump violated the 14th Amendment, Section 3, and could be disqualified and banned from the ballot. That's how we got here. The main case about the Maine Secretary of State is involved as well, and all the other states that are considering it are looking for guidance from the United States Supreme Court. But the that's how the issue sort of got framed right there. Now, that issue, which is going to be argued before the Supreme Court in oral argument, and like I said, we'll cover it there. Again, the Solicitor General is not taking a position. Trump's lawyers are there, the crew lawyers are there, the amicus briefs, the friends of the court briefs are there, but the Solicitor General, in taking a position on behalf of the United States of America, is not there. And so, I want to just completely debunk any theory that Biden is weaponizing for election interference this particular case. Biden is not even at the table. He doesn't even, his Solicitor General doesn't even have a seat at the table. She's not even an observer. She's not even going to be there. She didn't file a brief. So let me just clear that up right now. That's April. We'll get a decision from that, given the timing of everything, quickly. I would expect that we'll get a decision, assuming the ballots have to be printed for November, sometime in August, we will get a decision before August. We might get a decision as soon as, let's say April. But we'll see. They're on their own timetable, just to clear it up. The Supreme Court sets its own timetable. There's no schedule. There's no rule book that says how long it can take them to render a decision. They render it when they render it. After they hear the oral argument, they'll meet in caucus. They'll decide the votes. They'll decide who's going to write the majority opinion as selected by the Chief Justice Roberts. If he's in the majority, he'll write the opinion or assign it to somebody. If he's not in the majority, the senior most person in the majority vote would write the decision. That's how that works. So that's decision one. That comes off in April. That comes off a Thursday oral argument. But in April, something that's been sort of below the radar, and I want to bring it to your attention on this hot take, is running. There has been an appeal from the D.C. trial court level of a decision that went up to the D.C. Court of Appeals as to whether the obstruction of an official proceeding, which was the second highest criminal charge used by the Department of Justice in their indictments, including against Donald Trump, under seditious conspiracy, but also carrying a 20-year prison sentence for obstructing an official proceeding, whether that's an appropriate crime to use for the facts that have been alleged against these defendants. So the indictment basically reads that because the Jan 6 defendants and Donald Trump tried to interfere with the certification of the electoral votes by stopping the count, right, by trying to burn down the building and trying to hunt for elected officials who were involved with the certification, that was ultimately, obviously, obstruction of an official proceeding. Now, that statute, that crime, comes out of the around year 2000, out of the Enron financial scandal, which is sort of like FTX of its day, where there wasn't really a real business underneath the business, and the whole thing went under. It took a lot of stock owner money with it, right? Took a lot of investor money with it down the drain and required a bailout by the government and all of that. So there was a new law that was created, not retroactively to apply to Enron, but in the future, which was because Enron was giving its regulators BS, sort of bullshit records, cooked books, and the regulators couldn't figure out what was going on inside. And so they created for the future Enrons this obstruction of an official proceeding to create a new crime. Now look, when a prosecutor is indicting, he can only use the rule book that he has. Sure, the statute or the crime might have been created for a different scenario, but it doesn't mean by its literal terms it can't be applied to future crime. I mean, who could have anticipated that there'd be a former president who would commit insurrection or rebellion against the government to stop the peaceful transfer of power? You can only use the tools that are in your toolbox, and they found this statute, and they thought it's applicable by its terms, and I believe that it is. Almost every judge of the D.C. Trial court agreed, and many of the Jan 6 defendants have either pled guilty to that crime or have been convicted of that crime by a judge or a jury. But one judge, Judge Nichols, questioned whether it was appropriate and suggested in his decision that unless the Jan 6 defendants and Donald Trump got their hands on the actual physical ballots and ripped them up, which of course they didn't do, they didn't get in that far, thank God, then you couldn't use this count. That, I think, is a very narrow, ridiculous interpretation, unreasonable of the provision. And so the D.C. Court of Appeals, in a 2-1 decision, agreed with my interpretation of what I just laid out. It's up now on appeal with the United States Supreme Court. If the Supreme Court finds that the obstruction of an official proceeding is an appropriate count to have been used, great. All the Jan 6 people who were sentenced or are currently serving sentences are fine. If not, it'll open the jails to all the Jan 6 defendants convicted of that particular crime. It'll require resentencing if they were convicted of other crimes. And the 2 of the 4 counts against Donald Trump in the D.C. election interference case will be ripped away. I mean, he still has some good counts against him for the prosecutor's side, but, he'll lose 2 of the counts. In other words, he'll win. He'll have 2 of the counts removed from his indictment, and he can't be tried on that. So that's a giant April issue. And then you've got the last issue for this hot take, which, again, all in this term, think about this, for the United States Supreme Court. I mean, John Roberts must be losing his hair in his sleep, because this is not what he wanted to kind of round out the back 9 of his career as the Chief Justice. He's already going to be remembered as the Chief Justice when the Dobbs decision came out, ripping away a woman's right to choose and the constitutional right to an abortion and overturning Roe versus Wade. I mean, it's already a giant black mark on his tenure, right? In his obituary, it's going to be in the first line. Is the second line going to be that he's allowed a criminal president to overturn his indictment and to dismiss his indictment for criminal acts while he was in the presidency, or to have these, or to be on the ballot when he shouldn't have been on the ballot by misreading the 14th Amendment? Come on, John Roberts, how do you want your obituary to read? These are important considerations. And then lastly, we're waiting on the D.C. Court of Appeals. Once they ruled, sometime this week, I've been saying that for 3 weeks now, about that Donald Trump does not, I'm sure this is going to be the ruling that we're waiting on, Donald Trump does not have absolute presidential immunity from criminal indictment, to have his indictment dismissed in the District of Columbia because he happened to be occupying the Oval Office at the time that he committed the alleged crimes. That can't be the law for our land going forward. And I can't believe the Supreme Court would approve of that. DC Court of Appeals is the intermediary appellate court. They got to rule first. Once they rule, it'll come up to the Supreme Court. Jack Smith tried to take it directly to the Supreme Court, and they said, no, go back down through the DC Court of Appeals. And we want to hear from the Solicitor General at the appropriate time to have it briefed, and let's do it the normal way. So the normal way means we're not going to probably have it briefed and up at oral argument in the United States Supreme Court until like March or April. And the longer that goes, we're not going to have the DC election interference case until at least 2 months after it's returned to Judge Chutkan from the United States Supreme Court, assuming that the government wins those 2 rounds of appeal. So just add 2 months onto it. Why 2 months? Because Judge Chutkan has already said that 7 months of preparation for Donald Trump is fine. He's had 5 already, but then a pin got placed in it by the freezing of the case, the stay of the case, once he filed the appeal on the immunity. So now we got 2 more months that got to be added on to the back end. So when they rule, let's say the United States Supreme Court, for instance, rules in April, which is early. But let's say it's April. Then that means it's a June trial. If they rule in May, then it's a July trial. Now, if June, July is getting sort of late here to get the case tried before the November election, but it is still possible. It is still possible in a federal court to try a case over 2 months. So if they started in July, August, September, there's a jury verdict by September, which is still time for the voter to know whether Donald Trump is a convicted felon or not. Putting aside whether he's already convicted in New York, in the New York Supreme Court case related to Stormy Daniels and the cover-up. And 55%, I think, or so of Republicans say that they will not vote for Donald Trump if he's convicted. Even they won't vote for Donald Trump if he's a convicted felon. Although it takes that much. Apparently, for us, Democrats, indictment for 91 felony counts, being adjudged a rapist, having to pay, $83.5 million plus $5.2 million to your rape victim, that would sort of, any one of that would be enough for us, let alone another $500 million judgment coming down the pike in the next 2 weeks or so against Donald Trump in the New York civil fraud case by Judge Gore. I mean, I'm sorry, any one of those would be enough for us, but apparently the Republicans need all of those things and then a conviction in order to say, okay, all right, we're not going to vote for him now. Just mind-boggling. But we'll continue to follow this term of the United States Supreme Court the way we've done it. These 3 momentous cases, starting with Thursday with oral argument and April with the decision about the obstruction of an official proceeding counsel, whether they survive constitutional challenge, and then lastly, the oral argument that we know is coming involving the application of immunity of any type to Donald Trump's criminal conduct as alleged in the indictment. We'll do it one place, MeidasTouch Network, and on Legal AF on Wednesdays and Saturdays at 8 p.m. and on Hot Takes just like this one. If you like what I'm doing, give me a thumbs up, leave a comment. It helps with the ratings and keeps us on the air. But until my next Hot Take, until my next Legal AF, this is Michael Popok reporting.
Love this video? Make sure you stay up to date on the latest breaking news and all things Meidas by signing up to the MeidasTouch newsletter at MeidasTouch.com/newsletter.